By sunset, both of Tristan Noah Borlase's parents were gone for good. Just hours earlier, 17-year-old Tristan Noah Borlase had been grounded, his car keys confiscated, his phone taken, and his spot on the track team revoked. At the start of 2019, he was aiming to become a skilled pole vaulter, but slipping grades had his parents and teachers worried he might not graduate. By April 10th, their concerns boiled over into strict action, cutting him off from privileges and removing him from sports for the rest of the season. At the time, Tristan's mental and emotional state was unstable. Witnesses and mental health professionals later described him as impulsive and poor in judgment. Scars from earlier self-harm suggested he was dealing with serious emotional struggles. A forensic psychiatrist found that Tristan often felt torn between wanting to meet his mother's expectations and feeling unable to do so. That spring evening, the situation reached a breaking point. His father was outside working, and his mother was inside the home. Tristan suddenly turned physical toward his mother. He injured her multiple times with a sharp object, struck her with force, and then applied pressure to her neck until she stopped resisting. He then went outside and approached his father from behind. He injured him repeatedly with a sharp object. His father tried to get away, but Tristan chased him, got on his back until he fell, and then kept injuring him before leaving. During the trial, the court determined this was not a sudden, unplanned act. They found it was done with forethought and carried out in an intentional way. For about 2 hours afterward, Tristan tried to hide what had happened. He cleaned the living room and the porch. He tied a rope around his mother's body, dragged or dropped her several times, and eventually placed her in the back of the family truck under mulch. His father's body was later found under a hammock by Tristan's sister. After this, Tristan picked up his younger brother from their grandmother's home. He seemed unusually cheerful. Later, he left to use pot, leaving his brother in the home, which was still red-stained, while both parents were missing. He was taken into custody the next day in Tennessee. Tristan was formally charged in September 2019. His trial began in 2022. On March 2, 2022, the jury found him guilty on 2 counts of first-degree unlawful taking of life. The decision was based on proof that the acts were planned and deliberate. The next day, the court held a sentencing hearing. Under North Carolina law, the judge had to consider specific factors for young offenders, such as immaturity, mental health, chances for rehabilitation, and family background. Judge R. Gregory Horn decided to give Tristan 2 life sentences, to be served one after the other, with no chance of parole. Tristan later appealed. He argued that his sentence was unconstitutional for someone his age, and that the judge did not give enough weight to his difficult circumstances. But on January 2, 2024, the North Carolina Court of Appeals upheld the sentence in a 2-1 decision. The majority said the trial judge had considered all relevant factors. They also said Tristan's actions planning, trying to hide what happened, and showing little remorse proved irreparable corruption and permanent incorrigibility. One judge disagreed strongly. He said the ruling overlooked Tristan's young age, his family problems, mental health challenges, and unstable home life. He believed the law and constitutional protections for young people meant Tristan deserved another sentencing hearing. Tristan planned, cleaned up, and faced life without parole, but in the next case, volunteers searched the woods for days, unaware that one of them was hiding the truth. In March of 2014, 17-year-old Jamikiel Malloy was a high school senior in Hope Mills, North Carolina. He was in a relationship with 15-year-old Danielle Locklear. On March 11th, Danielle told her grandfather that she was going to visit a friend. She never returned home. By March 13th, her family reported her missing, and a large community search began. Malloy, who was her boyfriend at the time, joined the search like everyone else. But less than a month later, the truth came out. Malloy admitted that during an argument near a local creek, he had caused her to lose her life. He said he then placed her in the river to hide what had happened. On April 2nd, Danielle was found at the bottom of the South River. Her body was weighed down with cinder blocks tied with rope, and a sock had been placed in her mouth. The medical examiner said she lost her life due to lack of air, but it was unclear whether it was caused by pressure to the neck or by the sock. Malloy lived in Autryville, North Carolina, and had been with Danielle since June of 2013. He told investigators that on the night of March 11th, they got into an argument by the creek. During that heated moment, he placed his hands around her neck and put a sock in her mouth. He then called his friend, Dominic Tavon Locke, for help. Dominic admitted later that he pushed the sock further into her mouth because she was making noises. Together, they put her into the South River. Investigators began to suspect Malloy after finding inconsistencies in his story. Danielle's phone location data showed she had been near the creek late that night, not at a friend's house as she had said. Surveillance footage and phone records also proved that Malloy had not been at home when he claimed he was. Texts he sent to make it look like he was home were actually sent through a messaging app while he was still with Danielle. Authorities charged Malloy with second-degree taking of a life, describing it as an act done in the heat of the moment rather than something planned in advance. Dominic Locke was also charged, at first facing more serious accusations, but later he admitted guilt to helping after the fact. In 2016, Malloy pleaded guilty. At his sentencing, he looked at Danielle's family and said, "I know there is nothing I can do or say that is going to bring her back, but I do want to apologize for the actions I made. I know sorry does not cut it, but I want to say I am truly sorry." Danielle's mother, Rowna Fowler, spoke directly to him. She said, "You ripped out my soul." She described how she would never see her daughter get a diploma, walk down the aisle, or have a future. She told Malloy, "That was my only one. You took that away from me." Dominic Locke was sentenced to 6 to 8 years. He was released after serving about 8.5 years. Malloy received a sentence of 25 to 31 years. With credit for time already served, his projected release is in the year 2040. If Malloy serves the full term, he will spend about 26 years behind bars from his 2016 sentencing. For Danielle's family, that is a lifetime of grief. Malloy's last words in court were short and heavy with regret. "I am truly sorry." Malloy's case came from a young relationship that ended in a single tragic night. Now let's move on to a case where the accused was even younger, just 14 years old. Cameron Javon Speaks was just 14 years old when his life changed forever on January 16, 2021. That day, in Statesville, North Carolina, officers were called to a home on Rolling Lane. Inside, they found 39-year-old Christian Lee Colon. He had been struck by gunfire. His injuries were so severe that by the time help arrived, it was too late to save him. The home quickly became the focus of a full investigation. Detectives began speaking with witnesses. They collected evidence and tried to piece together how such a serious incident had happened in this quiet neighborhood. What immediately stood out was the age of the person they believed was responsible. He was not an adult. He wasn't even an older teenager. He was a young boy in his first years of high school. 2 days later, on January 18th, Cameron was taken into custody. At just 14, he was formally charged with a serious offense related to causing someone's passing, and also with firing a gun into a home where people were inside. These charges meant the court would handle the case with the full weight of the law, despite his age. When someone so young is accused of taking another person's life, questions quickly follow. What could have led him to do this? Did he and Colon have an argument? Did something happen in the moments before the gunfire? Or was it planned for reasons only Cameron knew? As the case went forward, these answers never became public. No official statement from the police explained a motive. No court testimony revealed a cause. This left a gap in understanding. We know what happened and who was charged, but not why. After Cameron's arrest, prosecutors began preparing their case. In North Carolina, second-degree charges of this kind mean causing the loss of life with intent, but without the detailed planning that defines first-degree cases. The state had to prove Cameron acted with that intent. Based on the final verdict, they succeeded. More than 2 years later, in May 2023, reports confirmed that Cameron was found guilty of ending Colon's life. He was also found guilty of the separate offense for firing into a home. These were not minor charges. They carried decades of prison time. Sentencing took place on June 7, 2023, in Iredell County Superior Court. Judge Joseph Crosswhite oversaw the hearing. The courtroom was serious. Both the defense and the prosecution were present, along with Colon's family. The judge reviewed the facts, the jury's decision, and the sentencing guidelines. For causing Colon's passing, Cameron received a sentence of 240 to 300 months, 20 to 25 years. For the weapons offense, he received an additional 31 to 50 months. After finishing his prison term, he must complete 36 months of supervised probation. This means Cameron will spend most of his adult life in prison. If he serves the minimum sentence, he will be close to 40 when released. At sentencing, families often speak about the impact of what happened. The record shows law enforcement and the district attorney's office were thanked for their work. Details about Colon's life, his family's grief, or their thoughts on the verdict were not widely shared. Still, the conviction may have brought them a measure of legal closure. For Cameron, the sentence ended his freedom for decades. Reports do not mention whether he apologized, remained silent, or spoke before leaving the courtroom. Since this was not a case involving capital punishment, there was no final meal. Looking back, the events in January 2021 moved quickly. On the 16th, Colin lost his life. By the 18th, Cameron was in custody. This fast timeline suggests investigators had strong evidentially witnessed statements, camera footage, or something directly linking him to the gun. The exact reason for the quick arrest is unknown. After the arrest, the case slowed to the usual pace of the justice system. Over 2 years passed before sentencing. During that time, Cameron would have been held in detention. These were years when most teens go to school, build friendships, and plan their future. For him, they were spent in legal meetings and living under strict custody rules. By sentencing day, Cameron was no longer the 14-year-old first taken into custody, but the court still judged him for his actions in January 2021, and the punishment was severe. As of 2025, Cameron is around 18 or 19 years old. He is serving his sentence in the North Carolina prison system. Up next are 2 teens gone, 1 SUV with red stains, and a suspect on the run. Ross lived in Mabin, North Carolina. He had only recently moved to the area. He attended Eastern Alamance High School for just 6 days, from August 29th to September 3rd, 2022. In court, his lawyers described him as a caring son and a brother to 3 siblings. They explained that he had been staying with relatives in Delaware after a disagreement with his mother. According to him, this explained why he was there when officers found him. There is little information about his earlier life, but that quiet life soon took a dark turn. In mid-September 2022, Lyric and Devin went missing. Lyric was reported missing on the night of September 16th. A neighbor recalled seeing her get into a car around 3 in the morning. Search dogs followed her scent into nearby woods. Devin was reported missing the following day. On September 18th, 2 men riding ATVs found both of them. They were hidden near a power line access path. They had been shot multiple times, and their lives ended in silence. The medical report showed a very troubling picture. Lyric had been shot at least 4 times, twice in the back, once in the arm, and once in the neck at close range. Devin had been shot at least 5 times, 3 in the back, 1 in the heel of his foot, and 1 at the back of the head. The evidence suggested it was intentional, not an accident. Investigators said the firearm used belonged to Devin's father. Inside Ross's mother's SUV, they found red stains and a red handprint. The evidence suggested that the shooting happened elsewhere, and then the bodies were moved. No shots were fired inside the vehicle. A witness later came forward. They claimed Ross had told them about what happened. According to the witness, Ross said the gun went off in the car during a struggle with Devin. He then shot both of them and left their bodies where they were found. That same week, Ross uploaded rap songs to SoundCloud. The lyrics spoke about aggressive acts, a headshot, a new Glock, and read, "Inside my car like I'm sipping on blood." After the discovery, Ross left for Delaware that same day. Officers already had a strong idea of where he was going. With help from Delaware authorities, the FBI Violent Crimes Task Force arrested him on October 5th at an apartment complex. 2 women in Delaware were later charged for helping him. Ross first appeared in court in late 2022. His lawyers requested bond and asked for some seized items to be returned. The courtroom was fulsome. People were there for the victims, while others came to support Ross. At a bond hearing in January 2023, prosecutors said the victims were shot while trying to get away. They emphasized the witness statement, the DNA evidence in the vehicle, the gun's ownership, and digital evidence from cell phones and cameras. The judge denied bond. Ross has remained in custody since then. On March 12, 2025, Ross entered a plea of not guilty. The trial is scheduled for October 27, 2025. The next victim was the most well-known student on campus, and that made her a target. And if you find stories like these important, consider subscribing for more. Lawrence Alvin Levette Jr. grew up in North Carolina. He was raised in what many described as a middle-class home. His parents cared for him and wanted the best for his future. When Lawrence was 12, his father passed away. This loss deeply affected him. Although his family tried to guide him in a positive direction, he began spending more time in risky environments. Between the ages of 13 and 16, his behavior worsened. It started with minor offenses. Then it escalated to more serious ones, such as entering private property without permission, taking vehicles without consent, breaking into places, and taking items that did not belong to him. By the time he turned 17, he had been found responsible for 16 major offenses and 7 lesser ones. This record made him a key figure in discussions about youth justice. He was one of the youngest people in the state at the time to be connected to an incident of such severity. On the night of March 5, 2008, Eve Marie Carson, who was the student body president at UNC Chapel Hill, was studying late in her home on Friendly Lane. Around 1:30 in the morning, a roommate saw her at her desk working on her laptop. A few hours later, around 4:30 in the morning, she and some of her belongings were missing. Her vehicle, a Toyota Highlander, was also gone. Lawrence, who was 17, joined 21-year-old Demario Atwater that night. Lawrence first called a friend to drive them, but the friend refused. Instead, Lawrence took his mother's car, and the two drove around Chapel Hill, looking for someone to take valuables from. They saw Eve walking toward her SUV. They pressured her into the vehicle and made her withdraw $700 from an ATM at University Mall in Chapel Hill. They then tried to withdraw money again in Durham, but it did not work. Eve spoke to them, saying they didn't need to do this, and suggesting they pray together. Later, Lawrence told a friend that she pleaded with them and tried to talk them out of harming her. She even asked them to pray. But because she had seen their faces, they believed they could not let her go. They drove to a wooded neighborhood about a mile from the campus. There, both used firearms. First, she was struck multiple times with a small caliber handgun in her shoulder, upper arm, lower back, and cheek. She was still alive at that point. Then a shot from a sawed-off shotgun passed through her right hand, which she raised to protect herself, and into her head. Witnesses nearby heard a woman scream, followed by several loud bangs. Around 5 in the morning, authorities found her on Hillcrest Drive near Hillcrest Circle. Lawrence was taken into custody on March 13th, just one day after Atwater was officially charged. Both faced multiple serious charges, including unlawful confinement, theft, and possession of stolen items. Atwater also faced federal charges involving taking a vehicle by force and illegal weapon possession. Because Lawrence was under 18, he could not face capital punishment under existing Supreme Court rulings. Investigators had strong evidence. Surveillance footage from an ATM showed Lawrence withdrawing money. DNA found in Eve's SUV matched his. In court, a confidential witness named Jason McNeil testified that both men had fired shots Lawrence with the handgun and Atwater with the shotgun. Lawrence said he was not guilty. His trial began on December 6, 2011. The prosecution presented DNA results, video footage, medical findings, and emotional witness accounts of what happened in the wooded area. The defense questioned the reliability of the evidence. They also argued that showing certain images from the scene could unfairly influence the jury. The judge allowed the images to be shown. After 2 weeks, on December 20th, the jury found Lawrence responsible for all charges. Judge R. Alan Badur sentenced him to life in prison with no chance of parole, which was the required sentence for such cases in North Carolina at that time. In 2012, the U.S. Supreme Court ruled that automatic life without parole sentences for juveniles were unconstitutional without considering their personal circumstances. The following year, the North Carolina Court of Appeals overturned Lawrence's sentence and sent it back for reconsideration. On June 3, 2013, Lawrence spoke in court. "You know, people make mistakes. Nobody's perfect. I'm not the monster that y'all made me out to be. I know that this has been a traumatic ordeal for everybody involved. For that, I send my condolences to everybody who's been affected by it. If it means anything to anybody, it means something to me." A psychologist, Dr. James Hilke, testified that Lawrence did not seem beyond rehabilitation. However, the judge saw little chance for improvement. Lawrence was again given a life without parole sentence. He appealed again, claiming he might have made different choices during the trial if he had known parole was possible. In 2014, the appeals court rejected his claim. The state Supreme Court also refused to change the outcome. Prosecutors had also accused him of being responsible for the passing of Duke graduate student Abhijit Mahato in January 2008. In July 2014, a jury found him not guilty in that case. Lawrence has been in prison since 2008. He was first at Pasquotank Correctional Institution. In April 2021, he was moved to Noose Correctional Institution. While incarcerated, he has been disciplined at least 15 times for actions such as threatening staff, ignoring orders, being connected to gang activity, having banned items, and sending unauthorized messages. He is now 34 years old and still serving life without parole. Lawrence's story leaves questions. Could things have been different if he had received more support after his father's passing? Could better intervention in his teen years have changed his path? When Eve asked them to pray, was there any real chance they would listen? Or was that moment already gone? His case became part of the discussion about youth sentencing in North Carolina. Lawmakers looked at his age, his past, and the seriousness of what happened to argue for changes to sentencing laws for minors. That debate continues. As of 2025, Lawrence Levette Jr. remains in prison for one of the most widely discussed cases in North Carolina's recent history. Lawrence's case drew national attention and raised questions about how the law treats teens. Keep that in mind as we look at other North Carolina youth cases that force the courts to weigh age, background, and punishment. Up next are two teens from the same school, an old dispute, and a second encounter that turned fatal. Shawn Simpson lived in Gastonia, North Carolina. 2 years before the incident, he and his 6-year-old brother lost both their mother and their aunt. The boys were raised by their grandmother, Joyce Simpson. She said she was shocked when officers came for Shawn. At the time, Shawn was receiving care for emotional and behavioral struggles at the Gaston Adolescent Center. That's where the officers found him. When Joyce visited him later, Shawn seemed more concerned about her than about himself. They both knew life was about to change for them in a big way. Zaquavius Dawkins was known as Tank to his friends and family. He was an honor roll student and played football for Ashbrook High School. He also cared for his mother, who lived with a disability. His family remembered him as cheerful, helpful, and kind. Tank had dealt with health issues earlier in life, but once cleared, he saw sports as his way forward. His cousin, Yana Galloway, said Tank dreamed of taking his family out of hardship. His mother recalled their last conversation. Tank kissed her and said, "I'll be back." She told him, "I love you too." On Sunday, January 26, 2025, just before 6 in the evening, Tank walked with a friend to a store. He was buying supplies for his mother. A black Tesla drove by. A voice from the back seat, later identified as Shawn, shouted something at them. The boys ran. The car came back. From the back seat, Shawn was said to have used a firearm. A bullet struck Tank in the right shoulder. He collapsed in a parking lot and his injuries were severe. He was taken to the hospital, where he passed away. His friend was also hurt but survived. Investigators later said the reason may have been an earlier dispute between the two teens at Ashbrook High School. It was thought to be settled, but it might not have been forgotten. 2 days later, officers found Shawn at the Gaston Adolescent Center. He was still under treatment for his emotional and behavioral challenges. On January 29th, Shawn appeared in front of a judge. A new state law, effective from December 1st, 2024, allowed 16 and 17-year-olds accused of very serious acts to be treated as adults in court. The judge announced that Shawn would be tried as an adult. He was given a capital defender and denied bail. When Shawn heard this, he collapsed. He cried and couldn't stand up. He called out, "I love you, Mama. I love you, Mama," as officers led him away. The victim's family was there in court. They were deeply affected. Denise Wilson, Tank's aunt, said, "For him to not be here today, we're all heartbroken." Tank's grandmother, Eveliana Dawkins, said, "It's affecting everybody, even the neighborhood he lives in." Wilson also said, "You're out here doing grown-up things, and this is what's going to happen. You gotta face the consequences." Shawn's court date was set for February 18th, 2025. It could change if a grand jury makes a formal decision before then. As of mid-August 2025, the trial is still pending. No decision has been reached. There are no closing statements or other final details yet. Ashbrook High School released a message in Tank's memory. They said, "The Green Wave family is heartbroken as we remember Zaquavius Tank Dawkins, scholar, athlete, kind and thoughtful soul. Tank will forever be a part of the Green Wave." Community leaders have been speaking out. Members of 101 Black Men for Highland shared a message. Stop the violence, let it go. They plan to help young people learn skills like proper manners and how to succeed in job interviews. They hope to reach hundreds over time, starting with smaller groups. Up next is a red Lexus, a famous license plate, and a victim who never made it home. Daniel Andre Green was born in Philadelphia. He later moved to Robeson County, North Carolina, when he was in the 3rd grade. Growing up wasn't easy for him. He had a stutter and often felt lonely and unsure of himself. Things began to change when he met Larry Martin Demery. Larry was a classmate from a Native American family in the area. He was patient, understanding, and kind. This led to a close friendship that would later play a central role in what happened. On the night of July 23, 1993, James R. Jordan Sr. stopped his red Lexus SC 400 near a Quality Inn along Interstate 95 in North Carolina. He was there to rest for a while. The license plate read UNC 0023, a reference to Michael Jordan's college and jersey number. Earlier that night, Green and Demery had been at a cookout. Sometime after 1:30 in the morning, Demery stepped away. Later, it was revealed that he went to handle a deal that turned tense. He returned upset and convinced Green to go with him. They drove to where Mr. Jordan was resting in his car. Demery claimed that Mr. Jordan was still sleeping when Green caused harm to him as he woke up. Afterward, they left his body in South Carolina. They also took his belongings, including his car phone, which later left a trail leading back to them. Green has always said he did not harm Mr. Jordan. He admitted to helping move the body, but insisted he was not present when the harm took place. In January 1996, Green went to trial. The entire case against him relied on Demery's testimony. Demery told the court that Green was the one who caused the harm. 2 forensic witnesses supported parts of his story. One said she found what looked like a dark stain in the Lexus. Another described a hole in the shirt Mr. Jordan was wearing in the chest area. Years later, it became clear that the DNA evidence was uncertain. The forensic analyst admitted she wasn't sure it was body fluids at all. Later tests did not confirm it. Those test results were never shared during the trial. Not long after, the evidence itself was destroyed. The shirt evidence also didn't match perfectly. The autopsy mentioned no chest area hole, only 3 holes in the lower part, suggesting the shirt may have been lifted at some point. But at trial, the testimony supported the state's version of events. Green's defense team also made mistakes. They did not call promised alibi witnesses, including the young woman he said he had been with that evening. One juror had also been accused of misconduct by a defense witness, but this was never brought up during jury discussions. The jury found Daniel Andre Green guilty. He was given a life sentence and has been in prison ever since. In 2018, new evidence raised questions about the fairness of the trial. Green's team pointed to the problems with the DNA testing and the contradictions in the shirt evidence. A judge agreed to hold a hearing, but in 2019 refused to grant a new trial. In 2023, Green tried to file charges, saying Demery lied in court to avoid a harsher punishment. He even claimed Demery's lawyer encouraged him to lie. Green represented himself in filing these claims. In 2024, Judge Gregory Weeks, the same judge who handled the original trial, said he was troubled by the case. He asked the parole commission to release Green, pointing to the suppressed DNA evidence as a major concern. Because the case happened before the 1994 Sentencing Act, Green can apply for parole. His co-defendant, Demery, was granted parole in 2020 but later lost it. Green's own parole hearing in 2021 included strong support from the NAACP and Reverend Tom Jones, who said, "I believed every word he said." However, Green's record in prison has 99 rule violations, far more than Demery. His request for parole was denied. To the parole commission, Green said, "Every day I live with the remorse and the pain and the suffering caused by my youthful decisions. I regret the harm my actions inflicted on the Jordan family." Today, Daniel Andre Green is in his early 50s and is still in prison in North Carolina. Now, how did a rifle from their grandfather's home end 2 careers in law enforcement that night? In September 1997, Kevin and his older brother Tillman were teenagers from the Richmond, Virginia area. They were desperate and decided to carry out a high-profile plan. They went into a finance office in Kingstree, South Carolina. They had a rifle, reportedly an SKS taken from their grandfather. The brothers made the employees go into a bathroom. They clicked the rifle and aimed it, but no shots were fired. They took a green Toyota Camry and left. This led to a "be on the lookout" alert for the car and those inside. About 2 hours later, State Trooper Ed Lowry stopped the Camry for a minor traffic issue. He let 17-year-old Kevin sit in his patrol car while he wrote a ticket. A dispatcher told him the car was stolen and the people in it might have a weapon. Trooper Lowry tried to handcuff Kevin. Kevin started to resist. Tillman, who was still in the Camry, reached for the SKS rifle from the back seat. He fired at Trooper Lowry and Cumberland County Deputy David Hathcock, who had come to help. Both officers were badly hurt. While they were down or struggling to move, Kevin took Trooper Lowry's service pistol and fired at both officers again at close range. He fired at Trooper Lowry several times and then fired at Deputy Hathcock again, even though they were already unable to defend themselves. The brothers left the scene and drove away. They crashed about 19 miles down Interstate 95. They ran on foot but were caught soon after. In 1998, Kevin went to trial. He was found guilty of taking the lives of both officers. The jury took only about 3.5 hours to reach a verdict. They recommended a capital sentence. Prosecutors described the events as cold and unnecessary Tillman using the rifle, followed by Kevin's close-range shots. The judge agreed and gave both brothers the capital sentence. In 2005, the U.S. Supreme Court ruled that capital punishment could not be given to people who were under 18 at the time of their offense. Kevin's sentence was changed to life in prison without the possibility of release. In 2012, the Miller v. Alabama ruling stated that life without release could not be automatically applied to those under 18. In 2016, the Montgomery v. Alabama, Louisiana ruling made Miller's decision apply to past cases as well. North Carolina then created a process for new sentencing hearings for such cases. Tillman's case changed for a different reason. In 2012, his capital sentence was overturned under North Carolina's Racial Justice Act. This was due to findings of racial bias in jury selection, particularly the exclusion of black jurors. He was resentenced to life without release. In 2013, the law was repealed, but in 2020, the North Carolina Supreme Court ruled that once the capital sentence was overturned under the Racial Justice Act, it could not be reinstated. His life sentence remained permanent. Kevin later sought a new sentencing hearing under the Miller and Montgomery rulings. In 2018, he filed a request. The hearing took place in April 2022. The court reviewed 9 factors, including his age at the time, maturity, past trauma, learning challenges, mental health, and potential for change. His lawyers brought in experts, including pediatric neuropsychologists and forensic psychologists, as well as records from his childhood, school, mental health assessments, and a letter from his wife. Kevin spoke about having no structure before prison. He said he had earned his GED, read books, prayed, meditated, and completed anger management programs. The judge, however, decided his actions were not due to teenage immaturity, but to what he called permanent incorrigibility. He said Kevin's decision to fire again at 2 already injured officers showed a level of harm that outweighed the positive points in his favor. The court also looked at Kevin's prison record. He had many disciplinary issues over the years, including nearly 10 years in solitary confinement because of an escape plan. In later years, his behavior improved, with only small rule violations after around 2014. Still, the judge and an appeals panel said his earlier conduct carried more weight. In February 2024, the North Carolina Court of Appeals unanimously upheld his life sentence without release. They said the trial judge did not make a mistake in how he considered the evidence, even if other judges might have placed more value on Kevin's improvements. The full appellate court did not agree to review the case further. Now, how did trust lead the next victim straight into a trap he would never escape? Ryan Patrick Hare was a teenager from near Apex, North Carolina. Earlier in 2008, he left Panther Creek High School. This was only a short time before the events took place. Little is known about his family life. Most reports focused on his on and off relationship with Allegra Rose Dahlquist. Friends said there were tensions linked to that relationship. Those tensions later became part of a much darker situation. Hare's circle of friends was close. Many of them were dealing with personal struggles. This included emotional health issues and feeling cut off from others. These struggles formed the background to what happened next. In late November 2008, Hare became jealous of how close Matthew Silliman and Allegra were. That jealousy turned into a disturbing plan. Prosecutors later described it as something like a strange movie plot. Before Thanksgiving, Hare told others he was being pressured by a man named Roger. He claimed this man was upset about Matthew's friendship with Allegra, but Roger never existed. It was a story Hare invented. He used it to scare and influence both Matthew and Allegra. On November 25, 2008, Hare and others tried to harm Matthew using a wire tie. It did not work. During Thanksgiving weekend, they convinced Matthew to come to an abandoned mobile home in New Hill. The property reportedly belonged to Allegra's family. Inside, they pretended to do a tarot card reading. While Matthew was distracted, Hare hit him on the head with a hammer. He was hurt, but still alive. When that did not end things, they gave him wine mixed with horse tranquilizers. Matthew became drowsy and passed out. They tied his hands and feet with zip ties. They covered his mouth with tape. Then they placed a plastic bag over his head, put him inside a sleeping bag, and left him in a windowless bathroom. He was unable to breathe and passed away. When Matthew's family reported him missing, deputies began searching. On December 3, 2008, they found his body inside that trailer. The home was in disarray. There were pill bottles scattered around and tarot cards on a table. Matthew had words and symbols marked on his arms. His hair was matted with dried red fluids, and bindings in the plastic bag were still in place. The trial took place in Superior Court in Wake County in September 2010. Prosecutors called Hare the main planner. They said jealousy was his reason. They also told jurors that the group had even dug a hole near railroad tracks, possibly to hide what happened. Drew Shaw, one of the people involved, testified in court. He said Hare kept pushing him to help, including asking him to find substances that would make Matthew unconscious. Allegra also testified under a plea agreement. She said Hare ordered the hammer strike and described the rest of what happened. After about 5 hours of jury discussion, Hare was found guilty of planning and carrying out the act, as well as trying to harm Matthew earlier and making plans with others for both attempts. The judge sentenced Hare to life in prison without parole for the main charge. He also received 12 to 15 years for the other convictions. When it was his turn to speak, Hare said, "I would like to apologize to the Silliman family for my part in all this. I don't believe the entire truth is known, but most of it has been. Why did Matthew believe the Rogers story enough to go with them? The prosecution said it was because of trust. He thought of them as friends. In particular, he trusted Adil Khan, his closest friend. The defense suggested it was actually Khan who manipulated Hare. They argued Hare might have been influenced rather than being the leader, but the jury accepted the prosecution's version. The next 13-year-old's childhood ended the night he carried out his uncle's instructions. Joseph Jones was only 13 when he became involved in an incident that would shape the rest of his life. His childhood was filled with instability and difficult moments. Some of his earliest memories were visiting his father in prison. When his father was released, both of Joseph's parents moved to New Jersey. They left him behind in Burlington, North Carolina. Joseph then went to live with his young aunt and uncle. They had trouble guiding him, and instead pulled him into a situation he could not escape. This was how Joseph fell under the influence of his uncle and the uncle's girlfriend. It was the beginning of the actions he would later be remembered for. In 1998, Joseph followed the instructions of his 16-year-old uncle and his uncle's 17-year-old girlfriend. Together, they were involved in harming a 10-year-old girl from their neighborhood in Burlington. Joseph was only 13 at the time. Soon after, he was taken into custody. He became one of the youngest people in North Carolina and in the entire country to be found guilty of something this serious. People often ask why he went along with it. Was it fear? Was it trust in older relatives? Joseph himself has said that he was a stupid little kid who was manipulated into doing something he can never undo. He was tried in juvenile court. His lawyer was facing a suspension of their law license during the trial, which raised serious concerns about the defense he received. Because the laws at the time required a set punishment, the judge had no choice. The sentence was life in prison with no chance of release. The court could not consider his young age or personal circumstances. At only 13, Joseph was told he would spend the rest of his life behind bars. Cases like his were extremely rare, making him stand out in legal records. Today, Joseph is still in custody at Noose Correctional Institution, a medium-security facility in Goldsboro, North Carolina. In an interview there in 2025, he shared how heavily his actions still weigh on him. His early years in the system left lasting marks. He remembered being sent to the high-rise youth facility. It was a tall 16-story building where other kids called him Baby J. From his first day, he had to learn how to protect himself. "I fought for my life in there," he said. "We all had to. And in some ways I'm still fighting." Even now, he says the incident still stays on his mind. "Nothing I say or do now can change it," he explained. "I try to be the best person I can be, but I don't know if I'll ever fully move past something I did as a stupid little kid." North Carolina's laws have changed since then. Research on how young people's brains develop, along with rulings from the Supreme Court, has shifted how the state treats youth offenders. Since 2021, the Juvenile Sentencing Review Board has been looking at cases like Joseph's. They consider whether to grant clemency or reduce sentences. Out of almost 200 requests, 12 people have been released during Governor Roy Cooper's time in office. Joseph is one of 75 whose cases are still waiting to be reviewed by the new governor. The legal system continues to evolve. Courts now recognize that age matters in sentencing. Mandatory life terms for children are increasingly seen as unconstitutional under the Eighth Amendment. In 2022, the North Carolina Supreme Court ruled that sentences longer than 40 years are essentially the same as life without release, unless the person is judged as having no chance of change.